But welcome. It's lovely to see you all, either in person and also people who've joined us online. Welcome. It's great to have you here. My name's Jennifer Jones-Casey. I'm the chair of the Pupillage Committee in Chambers. I've been a member of Chambers, or in Chambers anyway, since 2004. And I joined as a third six pupil shortly after doing pupillage at an insurance and shipping set. I've been doing construction and engineering work ever since. And in a moment, I'll get my colleagues to introduce themselves as well. But before I do that, let me just tell you all the plan for the evening. So we are going to have a conversation about various things to do with life at the commercial bar, the construction bar, applications for pupillage and so on, for probably about 40 or 45 minutes. And then the remaining 15, 20 minutes of the session we've set aside for questions. Oh, no, that's all right, I think. Sorry. Only one of us has been briefed on the tech and it may go wrong. That laptop over there is doing sound, not this laptop.
Someone said it was on mute anyway. I think I resolved it.
Yes, sorry about that. So we'll have about 15, 20 minutes for questions at the end, either from you guys in the room, we'll do our best to answer them, but also for everybody online, we have a Q&A box on the Zoom window. So if you have any questions as we go, please do put them in there and we will go through as many of them as we can at the end of the session. Once we've done that, it should be about still on mute. Right, sorry, the online attendees think it's not working. David, would you mind desperately going to get Beth and Oh no.
Yeah.
Was that you?
No, I tried to unmute it
and disaster ensued. And we've got it. Is it all right, Beth? Okay,
okay.
Lovely. Thank you. Oh, it's possible the person who is on mute. Yes, everyone else is saying it's working. I think we've got one person on mute whose tech isn't working, but everyone else is fine. Right.
They just forgot to turn on their speakers, possibly.
Perhaps. Well, that happens to me all the time. But yes, once we get to about 6:30, we will release all of you who are online with thanks, and then we have some drinks for those of you who want to stay and have a bit more of a chat. So with that preamble, we'll start off with all of my colleagues just introducing themselves and telling you a bit about who they are and what they do. Should we start with you, Mathias?
Sure, thanks very much, Jennifer. So, hi everyone, thank you so much for coming here in person and also online this evening. So, I'm Mathias Cheung. I am a sort of junior tenant at Atkin Chambers, and I've been with Chambers since 2016, so I'm coming up to almost sort of 10 years now, working as a junior barrister here. I started off as a sort of uni student here in London. I came to London in 2010. Before that, I was in Hong Kong, so I spent the sort of first 18 years of my life in Hong Kong, and then has spent almost more than that now since then in London. So I was an international student. I was at King's College London, in fact, so like many of you here. I studied in London, I was in uni, I did a straight LLB. So I was a straight law student and finished my LLB. I went on to do a master's afterwards. I sort of was quite fortunate. I got into the BCL in Oxford, so I did that. And then I came back to London to do my bar school here, just next door actually, when City Law School still used to be in Gray's Inn. Now that they've sort of moved back to, I think, Northampton Square probably. But I basically haven't left Gray's Inn since starting bar school. So I was quite sort of fortunate to be taken on by Chambers. As I've said, been practicing for about 10 years now. And I think, like many of us in Chambers, my practice is a general commercial practice, but then with a particular specialism in construction-related disputes. And when I say construction, you might think, oh, what is that? Particularly if you haven't sort of done any of that sort of work or come across any of those sort of issues in the mood before. It's really just, talking about disputes which arise from construction projects. And when we say construction, it could be, your general residential commercial building being constructed, could be an infrastructure project like a highway, an airport, could be an energy project, building a power plant, building a nuclear plant, for instance, at Hinkley Point. All of those sorts of things are sort of wrapped up into construction. So I've been doing that for the past 10 years. That I would say probably be sort of 60-70% of my work. And in that time, I've also sort of done a lot of work both sort of abroad and domestically. So I've done I remember sort of starting off as a sort of junior tenant after pupillage. I was thrown into an arbitration out in Hong Kong within almost a year. I mean, my background, I think, helped a little bit because of my language skills. But nonetheless, it sort of shows how, if you have the appetite for that sort of work, you can start doing international work quite early on in your career, which I think is one of the unique features of, first of all, being a commercial barrister, but also particularly with construction, because construction lends itself to a lot of international work. And Hong Kong is obviously just one very small example, but then since then I've done work in Singapore, in South Africa, in South America, the Caribbean, the Middle East, North Africa. So the whole lot, obviously UK as well. But then you will be looking at work which sort of goes from the smallest to the lowest level when you're junior, maybe a bit of county court disputes, a bit more sort of domestic disputes. Granny's sort of conservatory fell down, and because they got the sort of cowboy contractor in, that sort of thing, you would be dealing with a bit of that potentially, which is quite good for cutting your teeth, which I've done when I was sort of a little bit more junior. But then you can go on to do bigger cases with a wider team. You get led by sort of senior juniors and so like Jennifer, and you will work on big cases on a big team on arbitration. So I've done arbitrations in relation to power plants abroad, for example, in the UAE, various projects in South Africa, as I've said, and you're almost inevitably working with other people as well. So it's true that, of course, as a barrister, sometimes you do work alone quite a lot as well, particularly with your written work. If you're not in court, you're doing advisory work on your own potentially, but you also have a balance between both written and oral work, and you will work with bigger teams on bigger cases. And then eventually you get to a stage where you might also start sort of leading other people sort of who are a little bit more junior than you, and you're working with other people. Like at the moment, I'm working with David, actually, just as of last week, working on something together on an arbitration. So your practice kind of evolves over time. And what is interesting is that a lot of these issues, I mean, it might sound quite cryptic to you now if you haven't done this before. I mean, I didn't do many pupillage before coming to Chambers in construction, but nonetheless, what I found is that you end up applying a lot of what you've learned in law school, like contract law, tort law, negligence, those sorts of principles, to a very particular context. Yes, I mean, you come across very particular types of standard form contracts, which are only found in construction, but then really, ultimately, you're applying those general principles in a specific context, and you can learn a lot of that on job during pupillage and also in your early years of tenancy. So I think if there's anything you want to take away from tonight, from me at least, it would be that don't feel daunted that this is a bit of a niche area which you don't understand very much. We all started that way, and then you just get better in your job over time, and it's really just thinking about, okay, do I want to do things which are to do with like contractual disputes, disputes about professional negligence and that sort of thing.
Thank you very much, Mathias. Olivia.
Hi everybody, I'm Olivia Anderson. I joined Atkin as a pupil in 2022, and I got tenancy a year later, so I've been a tenant now for about 2 years. And it is amazing how quickly you learn just in those first 2 years as a tenant, and how quickly things change from the beginning of your practice to sort of where I am now. But I think later on I'm going to talk about life as a junior tenant, so I won't go too into that. But I studied, just about my journey to the bar, I studied history at uni as an undergrad. I was then fortunate enough I got a training contract, and I didn't, as a student, I didn't actually think too hard about the difference between a solicitor and a barrister. I knew I wanted to have a job that involved words, reading and writing, applying rules to factual matrices, and I thought, okay, well, law is a good fit. I'm interested in the application of logical principles to complicated facts, and I like words and contracts. So yeah, law seemed like a natural fit. I got a training contract because I think law firms are very good at sort of talking to students in a way that perhaps Chambers don't as frequently, just because we're smaller and we're all self-employed. It's a bit harder for members of Chambers to get out in the same way that law firms are able to. And I qualified into the project finance team, which is a particular type of financial product. It's a sort of huge mortgage to do with energy infrastructure projects. So that's what I worked on. I did a lot of work, about 3 years, on financing wind farms. And I thought, I really like law. I really like this industry, the construction industry. I was interested in the projects because they were international. As Mathias said, naturally, as a junior tenant, I went to Jeddah for an arbitration. I think that was in my first 6 months of tenancy. So exactly as Mathias said, you do get that international exposure very quickly. I also like the fact that in construction and energy infrastructure, you get to talk to lots of different sorts of people. You get to talk to engineers, architects, contractors, financiers. Lots of different types of people in industry are all involved in construction projects. And that, to me, was very interesting and very different to the standard life of a lawyer, I thought. So I knew that I wanted to do something to do with law, something to do with construction, but because I wasn't in the disputes team, I found that I was doing a lot more transactional work than I wanted to, and I was actually more interested in what happens after the contract is signed, what happens when these projects are up and running and things go wrong. And part of my role as a junior associate was to look at sort of force majeure events and the beginnings of potential disputes, and because we acted for loads of banks, to try and interpret the contract and sort of head off these, or to understand a bit what was going to come down the line. And I thought that was what was really interesting, the questions of contractual interpretation. And I wanted to get more under the skin of academic law and how the authorities interact with these huge projects. So I thought, I want to be a barrister. I also wanted to advocate, which isn't something you get to do as a transactional lawyer. So I applied to Atkin, and very happily I got pupillage. Yeah, and I've been tenant for 2 years, and I think it's really the best job in the world. And I'm really happy to come into this building every day. And I think when you talk to lots of barristers, they all really love their jobs. It can be stressful and it's hard work, but there's an energy to being a barrister that I really enjoy. So yeah, that's my introduction.
Oh, thank you very much, Olivia. I agree. We are a lucky bunch.
Yeah.
David.
Yeah. Hi everyone. I'm David Horwich.
Come in. Just grab a seat.
Excuse me. I'm one of the 2 newest junior tenants in these chambers. I finished pupillage this past September. I started the previous September. Just about my sort of journey here, I studied French and German originally, focusing on literature. I then did a master's in French literature, but sort of from a relatively early stage, I knew that the end goal was going to be the bar in some way or of some kind. And so sort of during my undergrad a little bit, and then during my master's a little bit, and then definitely during the UDL, I started to do lots of mini pupillages in different chambers in vastly different areas. I did some crime ones, some planning ones, some other public law ones, and a number of construction mini pupillages and some marshalling. And I decided relatively quickly that that was the area I was most interested in. So I applied for pupillage on the GDL and the bar course, and was fortunate enough to obtain pupillage here. I then spent the year in between getting the offer of pupillage and actually starting as a county court advocate for LPC law, going around the country doing sort of small county court hearings. And then for the past year I've been doing pupillage, which I'll talk a bit more about in a moment. But in the past sort of 3 months as a tenant, I have, I've seen a lot. I've actually been extremely lucky in that in those 3 months, I have been brought on to 2 large arbitrations. One, as Mathias said, with Mathias in Hong Kong, and another one which is London seated, but an international arbitration about a project on an island in the Mediterranean, which may continue for the next few years. So I think I've had a pretty good start, and looking forward to seeing how things pan out.
Thank you very much. And that takes us nicely into our first topic, which is just to touch for any of you who haven't done undergraduate law degrees. on the path to the bar if you are a non-law student. And David, since you've done that, I thought you might have some initial thoughts.
Yeah, so as I said, I studied languages, and in a very similar way to Olivia, what I was interested in was language, and I wanted a job which would involve probably a lot of reading, a lot of writing, and a lot of thinking quite carefully about how words, sentences, clauses, paragraphs work together. And I sort of looked around and figured out bar is by far and away the best way to do that. It's certainly the best way to do that, and also to have sort of the consistency and to a large extent security of a profession. So I think it's important, if you are coming from a non-law background, to spend some time thinking about why it is you want to be a barrister, because obviously that's probably the question that you're asked in virtually every pupillage interview, if not on the written application. So it's worth thinking quite carefully about why you want to do that. And then obviously what you should be doing is feeding your experience, if you are a non-law student, into that. And I think you often have to be slightly creative, I think, in these applications, but I think it's a legitimate creativity and I think, most academic subjects do have some relevance. So things like mathematics obviously would have some relevance to a construction law set where we deal with disputes that are technical, but you might think about the fact that you enjoy logical arguments which lead to a conclusion. For example, languages, I think, has an obvious application. History, again, has an obvious application. Virtually every subject where you spend time thinking about arguments and writing those arguments in a detailed form. So I think it is worth doing that. It's then, as I said, worth spending the time figuring out which areas of law you're interested in, because obviously if not every area of law that exists in practice is taught at undergrad law or even a master's or PhD level. But a law student will probably have a bit of a head start in terms of knowing what they find interesting. And so I think it's a good idea during the year to go to things like this, do lots of mini pupillages in lots of different areas, and just to be open-minded, because you really don't know what you're interested in until you see it. And I think you have the ability to do that at that stage in your career. Now, it's important to note that in these chambers, we're not snobbish either way. So there are many members of chambers who didn't study law. Equally, there are many members of chambers who've studied law to the very highest level. And so, it really, it's about the way in which you market yourself, and also the way in which you apply your particular set of skills to the job at hand. Construction law is an academic subject. Many of the disputes we deal with are conceptually, legally, academically very difficult, and lots of the most important contract and tort cases are construction cases, and so it's useful to know about the law. But during pupillage, for example, I don't think it's a significant advantage or disadvantage, because I think by that stage, what really matters is your ability to pick things up quickly. So during pupillage, if you have studied law, you will be using a lot of the things that you've learned during pupillage, but you will be applying them probably in a very new way, and you will have to relearn lots of those things. And then if you haven't studied law, like I didn't, you may just be learning that those things exist for the first time and then learning them. But the gap between those two activities is not as great as you probably think it is.
I mean, I would just pick up on that. So I've had, Mathias was my pupil, these two were not, but anyone sort of within about 10 years of Mathias in Chambers was my pupil. I've had a lot of pupils. And as a supervisor, there is a definite distinction at the start of the year between the people who've studied law at undergraduate and the people who hadn't. It's there, it's obvious. It is a steeper learning curve as regards the law for the non-law undergraduates. But the thing is, pupillage is difficult. It's hopefully sort of quite enjoyable as well, but it is a challenging year, and the challenges are different for everybody. So a non-law student will have a bit of catching up to do in the first few months, which we, and I think most decent sets, treat the first few months as very much a learning time. Everyone recognises there's a lot to learn. Non-law students have a bit of a steeper hill, I would say, in those first few months, but then law students will have other things that they have to focus on and they're perhaps less immediately strong on. So it's very much horses for courses, I would say.
Yeah, I think that's right.
Yeah, but that takes us on to your topic, or your next topic, which is what we, and I suspect a lot of commercial sets, to be honest, but we're focusing on ourselves, look for in candidates.
Right, well, so I think first thing before I start going into the details of that is I can't sort of recommend enough that you should read sort of the pupillage policies, which is not just for our chambers. We have a policy as well on our website which you can find, but then in most chambers they will also publish their sort of pupillage policy or criteria, and they will basically tell you, okay, well, these are the sort of targets you need to hit in order to sort of get pupillage, and also sometimes they tell you about, you know, how you get assessed for tenancy as well, which are probably, you know, similar, if not the same criteria. For our purposes, it's probably the same criteria. So quite important when you're preparing for an application, not just for the interviews, but for the application when you're sort of doing either your gateway forms for those who are sort of in the gateways, and also for the other sets which, you know, like ourselves, where, you know, we do sort of cover letter and that sort of thing, for example. It's very important to read that policy quite carefully first before you start doing your application, so that you know, okay, well, that's the sort of, you know, that's what I'm shooting for, practically, so you're not sort of just groping in the dark a little bit. So for our purposes, I mean, we're looking for, in very general terms, without sort of going into the granular detail yet, I think in general terms we're looking for sort of someone's potential to do the work that we do and to excel at it and to be good at it, and also to enjoy that as well. I mean, it's a bit of both, you know, we're not just looking for robots who would just keep, you know, working 24/7, so we want people who actually enjoy the work and can become, you know, quite passionate about their work as well at the same time. So that's really ultimately what we're looking for, and then obviously in order to assess whether, you know, that person has or has not that sort of potential, then we'll have to look at some sort of criteria in order to help us make sure that, you know, we sort of objectively assess each candidate sort of fairly and make sure that they are or really, you know, appropriate, suitable for us, and also, you know, we feel like they would be, you know, we would be suitable for them as well. And it's a kind of a two-way street. It's not just a sort of one-way street in many ways, because we all sort of work in chambers together. Ultimately, we're all friends and colleagues, so it's not just sort of, you know, us sort of employing someone and then just, you know, putting them to the grindstone and just making them work. So on that note, there are sort of five core criteria which we would look at. And I think it's worth noting them down. You don't necessarily have to sort of copy them because they are online, so you will find them in writing anyway. But we're looking for, first of all, sort of strength in legal analysis. We're looking for general intellectual capabilities. We're looking at the sort of potential for excelling at sort of written and oral advocacy, so advocacy skills, which every other set would look for, I'm sure. And then we're also looking for, just more generally, a potential capacity to build a successful practice in chambers. That's the fourth criteria. And then finally, we're looking at professionalism, integrity, and just generally a sense of responsibility. So those are the sort of five core criteria. And just briefly on each of those, so that you understand what we're looking for. On the first one, on legal analysis, it's really just demonstrating to the sort of committee, and when I say demonstrating, you know, you can do that both in the written application stage and also at the oral sort of interview stage, right? So you should be thinking about these criteria whichever stage of the application process you're in. So and it's all very much evidence-based. So think of it almost as if you're doing like a piece of submission or a piece of advocacy. Your application is kind of your advocacy. You're persuading us that you are a good candidate which we would like to interview, or if we've interviewed you, then, you know, we should offer you a tenancy. So it is a piece of advocacy for yourself. So always think about what evidence can you use to show that you've sort of fit all of those criteria. So legal analysis, really showing basically that you understand law, you keep up to date with legal developments, not saying that you need to know construction law, I mean, we wouldn't expect that necessarily, but showing an interest or some form of awareness of the sort of developments which are relevant to construction could be quite helpful, and would tell us, again, not just about your legal analysis, but also tells us about your sort of commitment to the sort of practice we have and your potential for that practice. So legal analysis is important, and then that sort of links up to intellectual capability and your ability to sort of digest and handle significant amounts of information, technical information sometimes, and often within sort of time pressures as well. So being able to demonstrate that, for example, show that, you've written a thesis, for example, or you've written a journal article on a very complex area of law with a lot of case law, for instance, these are not sort of set in stone, but showing that you have that ability, and of course, doing well in your degree as well, that would also be sort of quite a basic sort of primary evidence that you are sort of intellectually quite competent in the law in particular. But for non-law students in your own discipline, that's also quite transferable. And then it's really just talking about advocacy skills. And again, I think that's probably the one that needs least explanation, because obviously we're all barristers, so we're expected to sort of stand up in court or in an arbitration hearing to speak. So having some evidence that you've done, let's say, mooting, but not just mooting, maybe debating, anything that involves some form of advocacy. And also just remember that it's not always about oral advocacy, it's also about written advocacy. Because at the commercial bar, there's a lot of written advocacy that you need to do in terms of written submissions, etc. So showing that you can do a written piece of work in a persuasive way, for example, if you've written a brief for a particular charity, or you've been involved in a particular campaigning sort of initiative, both in writing or in sort of oral capacity, those are all good evidence. So think laterally about what you can do in order to sort of demonstrate that. And then finally, when it comes to sort of your potential to build a successful practice and to show that you are able to sort of act in a professional manner with integrity, all of those things are looking really for sort of basic sort of interpersonal skills and just general decency, I think. So you can just think about, again, examples from your sort of academic career so far. What sort of situations have you encountered which would show that, for example, that you're able to manage time properly, juggle different tasks, and use your time efficiently, manage people's expectations, and sometimes, you would also be asked, okay, well, for example, can you find a situation where you can show a sense of good judgment where it was a difficult ethical issue, for example? Not necessarily just outset, you might be asked in other sets as well about those questions. And again, just you have to sort of start accumulating those experiences and think about, okay, well, maybe I can deploy that in my application at some point. If you've encountered a particular situation where you've had to manage something quite difficult, again, that would be quite a good example to just note down so that you just forget them once you get to the application stage. But those are really the core criteria that we would look at and use to assess our pupils and also our sort of for tenancy as well in the future. And it's just worth bearing those in mind when you're applying for our sets and also for other sets generally, I think.
I would agree with that, and I would also pick up on one other thing, which is that we do care who you are as people, both because we're recruiting people who will spend decades in chambers, but also because, frankly, when you have hundreds of forms to read, they are boring. And we like to know who people are, because that helps us have more confidence that we are putting the right people through to interview, because we and all sets, and nobody interviews all of their applicants, but the overwhelming majority of applications are good. And so we mark against our criteria, which have been revised this year in case anyone's looked at us before, so do look at the new policy. We mark against our criteria, but a part of that is inevitably trying to work out who this person is. Yes, are they clever? Yes, are they going to be a good barrister? But also, who are they? Are they decent, as Mathias says? And so you shouldn't, that there's obviously a line and a question of judgment, but you shouldn't be scared of letting something of yourself show through in applications. And that, I think, feeds into a follow-up question I had for you, which is, you've given us some tips for applications. Do you have any tips for interviews?
Yeah, I think for interviews, it's, all of the things I've said about applications generally would apply to an interview as well, and also what Jennifer has rightly said. But I think probably what Jennifer has said just a moment ago applies in particular to an interview, because on paper, of course, you can show a bit of personality in terms of telling a bit of story, But then when it comes to an interview, that is really the moment when you're going to meet us in person, and you will have that opportunity to sort of let your personality shine through. And so just be quite aware that when you come into an interview, of course the nerves will always be there. There will always be a level of anxiety. I think that's something to bear in mind. And just because you feel a bit nervous before the interview doesn't mean this is not for me, or that this is too difficult. We've all been through that stage. In fact, for all of us, I think even before we go to court, we will feel a bit nervous. So I think having nerves is fine. Actually, a certain healthy dosage of nerves probably helps you to sort of make sure that you're sort of on the ball, you're sort of alert, and you will sort of deal with the questions properly. And it's no bad thing necessarily. But make sure you manage your nerves, and that's quite important, because sometimes what we see is that, okay, we know that this candidate is very good, and indeed we can see that they have the potential to be very good, but then if the nerves get a little bit too overwhelming, that they haven't managed it properly, it would just be counterproductive, and obviously we can see that. So if you want to sort of put your best foot forward in an interview, you have to work out a way to sort of manage those sort of nerves, and to sort of make sure that, okay, you can put on your best performance in an interview. Now it might sound like, okay, but this is easier said than done. It is in some ways. But I would say that a key tip for getting into an interview and making sure you can manage the nerves is to get used to that environment and that process. To be used to answering those questions and being put on the spot about those types of questions. And there's no better way of doing it than trying to do mock interviews. There are lots of different mock interviews being offered both in uni, in bar school, and also by the inns, of course, if you're a member of an inn. And they organize a lot of these processes, these sort of pupillage sort of workshops and sort of mock interviews. Very important that you try and do those, and do those as frequently as possible, particularly in the lead up to the actual interview, so that you're already in that zone. And once you're really habituated to that sort of situation, you will feel a little bit more comfortable. That's my sort of first tip. I think the second tip I would say is that in a lot of commercial, and actually not just commercials, but just general chambers, when you go into an interview, they will ask you questions which go a little bit beyond the law. So they might give you, for example, a discussion topic, like we would do, for example, which is not really to do necessarily about the law. It could be about the law, but it probably won't be. And it's a general topic of discussion which you can very easily have views on either side of the aisle, effectively, and it's not necessarily, there's no good or bad or right or wrong answer. Now, you might be given a choice in some chambers, in other chambers you might not. You might just be given the one topic, everyone's being assessed on that same topic, and that's it. So I think the important thing, that there's no real sort of set way of preparing for something like that. But I think it's important that throughout your sort of uni life and throughout your sort of your lead up to your application, just be aware generally of issues. Like read up, read widely. Be aware of topical issues which are in the news generally, or just things that people talk about. And so that you start thinking about those issues and having some degree of sort of basic familiarity with some of these issues. Otherwise, you might get asked a question, for example, about, I don't know, like AI, for example, and you have no idea what AI is. Pretty much impossible these days, you'd think, but it's still possible. So just having some basic level understanding would help you to answer that question better and formulate arguments better in a sensible way. And because you will have to prepare it on the spot without having the opportunity to do an actual AI search or any Google search, you would really want to be in a position where, okay, I can at least sort of put on a decent presentation at the interview. So being aware is quite important. And I think finally, it's before you come into an interview, I think it is quite important for you to really think about two particular things. First of all, why did you apply to this set of chambers? Now, I know all of us applied to like 10 sets, sometimes more, because that's just the way things go. You can't really sort of put all your eggs into one basket, or even just 12 baskets. So you need to go 20. But then sometimes we see candidates who've obviously come in and they haven't really thought about it. And it's just doing this sort of routine run-of-the-mill. This is an interview. I'm just going to sort of spill out the same stuff. And it sounds quite generic and it's not very well thought out. And it again comes across. So first thing to think about why are you applying to this set of chambers, and what do they do? Why am I interested in this area, and what do I want to achieve as a sort of pupil and junior tenant in the next couple of years? Where do I sort of see myself in terms of my practice? And then just secondly, more generally, you can also think about things which are interesting about yourself. Like what sets you apart from the other candidates? Because a lot of times, again, as Jennifer was saying just now, personality is quite important. We want to know about you as a person. So having some thought process about, okay, why am I so unique? as a candidate, what makes me different, would also help us, because then we can say, oh, well, I think that person is interesting because X, Y, Z, and that's different from the other person who's also equally good perhaps on the CV, but not the same person because of those reasons. And then it gives us something to sort of look at and assess. So think about all those things and think about them early. You can start thinking about them now and then crystallize those thoughts before you come into an interview. Those would be my tips.
Thanks very much. Sorry.
Can I just add one? Because this is something that someone told me and it completely changed my performance in interviews. So I always try and tell people, and for barristers this is very natural. If you're in court or if you're talking to your supervisor or you're getting instructions from a leader, you will have a pen and a piece of paper in front of you and you'll be writing down what they say. And in an interview, I think the same principles apply. And I was struggling at the beginning of my interview because I was being asked a question and I was thinking, oh my God, okay, well, I could say this and this. And then I was blurting out an answer very quickly, just cold. And it leads to a very bad and badly structured answer. It also, for me, led to lots of panics because I'd forget what they had asked me in the middle of my amazing answer. So for me, a complete game changer in interviews was I had a pen and a piece of paper and they were asking me questions and I was smiling, nodding, listening, taking notes. What were they asking me? And more importantly, how was I going to structure my answer? So while they were asking the question, these ideas would come and you can just make notes of what you're going to say. And then when you respond, you have this roadmap, which you can just hit. And very naturally, you look at the paper and then you make your points. And I don't think the panel would ever be surprised by that approach because that's what we all do at the bar. And I think a judge would find it very odd if they asked an advocate a question and the advocate just blurted back the first thing that they thought of. It's not what we do. So it's normal for a candidate, I think, to similarly take a beat, write down what you want to say, not read, just a few words. And that, for me, that really helped. So I just wanted to say that.
That's a good tip. Thank you. I'm going to move on chronologically because we're not a bit careful. We'll run out of time. David, life as a pupil. You're the one who've done it most recently, off you go.
Life as a pupil. So pupillage varies quite a lot from set to set, and even at the commercial bar, pupillages are different from one another. So I'll speak about what it's like here. We generally have 2 or 3 pupils, and then pupillage year really is around 9 or 10 months. So the tenancy decision comes in around June or July, with you having started in September. So it's actually a fairly short year. And it is technically split into 3 seats. So you sit with 3 different pupil supervisors for 3 months, and then 6 months. But I was thinking about this, and I actually think it's probably split into about 3 phases, which are an exploratory phase. So the first 3 or 4 months are you kind of finding your feet, doing things for the first time. So you might never have written an advice or long advice before, never have done a particular kind of pleading before, or a particular kind of skeleton. And also there will be probably quite a lot of legal issues, subheadings within contract law, which you might never have seen before. And you have the time in those few months to sit down with a problem for a week or 2 and to just think about it and then write an answer. And maybe you got it right, maybe you got it wrong. Obviously, you hope you get it right. But in that period of time, I think it's more important for you to be learning and doing things for the first time. After that, you have a sort of consolidation phase where you're doing essentially the same work, but there's a bit more of an expectation that you're in the right direction, and you probably will start to do things for the second time, start to see things that you recognise. And then the third phase is the assessment phase, which in these chambers is structured and formal and predictable. So it's in the pupillage policy, and you know when you start what it's going to be like, so you can prepare for it, which is nice. It's not the same everywhere. And so just to talk about the kind of work that you'll do, you essentially do a combination of live work and dead work. So some of the work that you will be effectively doing bits of your supervisor's work, and that just depends. It just depends what your supervisor has on at the moment. So, to give you an example of some live work, in my first seat, my supervisor was doing a trial in the Technology and Construction Court, being led by someone else in Chambers, and I was lucky enough to have basically the trial preparation period coincide with my seat, and so a lot of my work was going through opening submissions for the trial, looking at things like cross-examination notes, going through expert reports, sitting in on meetings with experts, even sitting in on conferences with witnesses, which was all really, really interesting. And then I got to see the trial towards the end of the seat, and then helped with some drafting and closing submissions, things like that. And most of those pieces of writing I had never done before, so it was useful to do them at that early stage. In my second seat, my supervisor was doing he had a case in the commercial court which had a lot of jurisdiction, conflict of laws issues surrounding essentially applications to serve out of the jurisdiction, which took a very, very long time. And so I spent a lot of time basically learning how conflict of laws worked, because I had never seen it on the GDL or after that. And that was basically a crash course in how that works. And I helped with drafting of skeletons, witness statements, that sort of thing. And so when you're doing live work, kind of depends what stage you're at and how that case will work, but generally you will be given the work and you will do it effectively in parallel with your supervisor, and then at the end both of you produce some work and you will be given your supervisor's piece of work and essentially asked to compare the two and to work out what's different from yours as compared to theirs, and you learn by doing that. So that's kind of the live work. At the same time, you'll do dead work, which is generally longer advices and longer pleadings, and that will involve being given usually a more formal letter of instruction to counsel from the solicitors, which says, we are seeking your advice on these 4 questions. This is how the project worked. Here are a load of documents. What's the answer? And you might spend a week, 2 weeks, 3 weeks, 2 months doing something like that, because probably if it's being given to you as a pupil, it's interesting but also quite difficult. And those pieces of work, again, can be really challenging, but they can teach you an enormous amount in the course of doing one advice. And so they're absolutely essential, and they do very much mirror a lot of the work in practice. So you do that work for around 7 months or so, and then the final 2 months are assessments, which effectively involve around 6 or 7 weeks of carrying out very similar pieces of work to the ones that you will have been doing over the course of pupillage. So it's split into 2 phases, but it can be thought of as essentially 6 or 7 weeks of doing about 1 piece of work a week, which will usually be an advice or a pleading, or sometimes both sort of in combination with one another. Again, they'll be legally interesting, factually quite difficult. They'll involve ethical issues, practical issues. You'll have questions like, should we instruct an expert witness? Has our expert witness got this wrong? You'll have to deal with things like the documents that you have been given are imperfect, things are missing. So those are sort of practical questions that as a barrister you have to deal with virtually every day. And as a pupil, you won't have had a huge amount of experience of that, but by that point in the pupillage, hopefully you will have seen a number of the legal issues before, and you will at least have an idea of how to approach something that's brand new. And that effectively forms the last period of pupillage, and then that's assessed, and you have the tenancy assessment.
Thank you very much. We've got a couple of final topics which I'm going to hand over to Olivia on. That you can probably take them together, I would have thought.
Yeah.
Both turning pupillage into tenancy, and then what practice is like when you start as a junior tenant.
David has touched on the assessments that arise predominantly at the end of the year of pupillage, but there are a few earlier on. As Mathias mentioned, the Pupillage Committee apply a set of criteria to the pupil in their application for tenancy, to assess that application for tenancy. Those criteria are very similar to the ones that are applied to prospective pupils. I think the two key ones that the committee want to see in the pupils are intellectual ability or grasp of the area that we work in, and also advocacy. And there are 3 advocacy assessments or exercises across the pupillage year. And we're very fortunate that we often do those, the pupils do those in front of existing or former judges. So there are those sort of formal assessments, and also each piece of work you do informs an impression that your supervisor will have of the merit of the pupil, which will be fed back to the Pupillage Committee, and then all these different criteria are given different weightings, and the committee will come to a decision on tenancy. Which does loom, I think it's something I didn't realise as an applicant, that the tenancy decision looms quite large during your time as a pupil. It's easy to see pupillage as an end in and of itself. And, on day one of pupillage, that goes away and you start to think about the next thing, as is life. One of the reasons I wanted to go to the construction bar is that there's a real gamut of disputes. As Mathias said, at the very junior end, there are small, disgruntled homeowners or disgruntled builders who haven't been paid. Homeowners apparently have defective works that have been performed on their private residence. And at the junior end, you can immediately start to act on those types of cases. You can also immediately start to act as junior counsel as part of a team, and be led by a much more senior member of Chambers on a significantly higher value dispute, which will involve significantly more complexity both in law and on the facts. So that is, I think, a real difference when you're a junior tenant compared to pupillage, because during pupillage your supervisor tends to be very, very senior, which means you look at their work or the work that they deem to be particularly helpful to people, and that work will be often very complex and very challenging, because that's how the people will learn, and you need exposure to all these difficult issues before you get tenancy. And then you get tenancy, and quite often the things you're working on suddenly are slightly less complex than you saw during pupillage, which I think is testament to how rigorous Atkin's pupillage is in particular. And it was something I was very grateful for when I began as a junior tenant, because particularly the panel work process that comes at the end, which is an assessment particular to Atkin, it's a very rigorous and quite intense period of assessment. And even now, I think sometimes if I'm very busy, I think, well, I did panel work, so this is completely fine compared to that. Not to put you off, panel work's fine as well, but it's just when you get junior tenancy, it's different to pupillage. You're doing it yourself, it's a job, so it feels different. As a junior tenant, so you can be working on these smaller disputes, you try and get into the county courts. You might, in the county courts, be working on things like strikeout applications or applications for summary judgment. Quick, interlocutory applications and hearings where you learn an awful lot, because it's slightly more Wild Westy. And actually, I think our advocacy assessments, they're judged and performed on the TCC, Technology Construction Court, so High Court principles. And then when you get to the county court, it's a bit of a surprise because things are a lot more conversational. The procedure takes on slightly more importance, which you might not have as much familiarity with as a pupil, because you're kind of doing you're focusing on academic legal issues. And suddenly you need to really brush up on the CPR as a junior tenant and know how practically things need to happen. So do you need to amend your particulars of claim? Why? How do you do that? Limitations coming up. Well, let's issue the claim form and then deal with particulars later. It's all these kinds of practical things that aren't academic. They're based on experience, and that's why it's helpful to chat to other members of chambers. So you can go into the county court, work on your advocacy. We also do something called adjudication, and that's what junior tenants spend a lot of time working on. I'm in the middle of one at the moment. Those are construction-specific, fast-track dispute resolution mechanisms, whereby an adjudicator will judge a dispute within about 28 days on the basis of papers that are submitted to him. It's written advocacy, and there'll be counsel on either side, or solicitors on one side, counsel on the other, whatever, and you have to argue forcefully for your client in a way that will land with your particular adjudicator, and that can be really great fun, because it's really the time when you can make long form written submissions and really get under the skin of the papers and talk to your experts, liaise with your solicitors, get witness statements in place if you need to, question your expert, make sure you understand the evidence that they're giving you. Do you have the evidence to make the submissions that you want to make? All those sorts of questions, which are slightly more practical maybe than just thinking about academic law. I think the one other thing to mention as a junior tenant is that's when you begin to have a relationship with your practice managers and the clerking team, and that again marks a significant change from pupillage, where you don't really come across the clerks very often. Early on in practice, we have a chat with our team leader of our clerking team, and they might ask, where do you want your practice to go? What are you interested in? But in general, at the very junior end, the advice is, and I think the intention of most junior tenants, is to just keep your practice as open as possible. Say yes to as many things as possible, and get as much experience as you can. Yeah, I think I've covered.
Thank you very much. We'll now perhaps switch to questions before it gets too late. We had a few questions through online about an earlier topic. So we'll deal with those first, because the people who asked them have been waiting for a little while. And then I'll open the floor to questions either in this room or any more questions online. So the first one, Atkin Chambers requires a CV and a cover letter as part of the paper application. Could you please clarify what you expect to see in those 2 pages of cover letter? Do you want to take that?
Yes. So I think in that cover letter, what we would want to see is it's basically our sort of first contact with your sort of written advocacy skills. So we want to see how you put together a little bit of argument on why you're the sort of candidate for us. So that's the sort of overarching objective, I think. In those 2 pages, we would hopefully want you to sort of address the sort of key points, that are the sort of criteria that we've already sort of talked about at length just now, about sort of how we assess our sort of pupils, also potential pupils, and the sort of core criteria that we look at. So we're looking for evidence which goes to each of those points. Similarly, in this interview process, it's really the same exercise. So just think about how in your cover letter you can address those points. And again, as I've mentioned just now, it's evidence-based. So of course you'll be providing your full CV, so we will consider your CV as well in the round. But then we would like to see how you would make use of that information in your CV and sort of amplify particular parts which might be helpful and which might not be sort of apparent. For example, from just a one line in the CV, oh, I was in the committee of the so-and-so society. What does that involve? Why does that show that you might have a particular skill set, which is what we're looking for as part of our pupillage criteria? So it's expanding on things which might not necessarily be apparent just from the page of the CV. It's using that evidence and sort of making sure that you draw to our attention particular parts of the CV which you think are worth emphasising, which are particularly relevant. Although we might read it, we will read everything. We might not necessarily sort of understand the significance of them, in particular when we're sort of looking through hundreds of applications at one time. So it's amplifying, clarifying, elaborating on those, and make sure you structure that letter so that it's not just stream of consciousness. Give some thought to how you want to structure it, addressing basically those points and showing explaining effectively why you want to come to Chambers, why you're interested in our area of practice, and why you're a good candidate for that. Basically, those 3 points you need to hit.
Fab, and that sort of feeds into the similar question. Do we have a template that one can use in order for the CV to be compliant with our requirements? And the answer in a word is no, because your CV is written advocacy. And so we want to see how candidates choose to present themselves, which is particularly important because we have a very wide range of candidates, different ages, different backgrounds, different educational backgrounds, different previous employment, if any. It's across the board. And so we prefer for people to choose how to do it themselves. The final of the older questions, before I come back to the room, although I will, for those questions that have popped up recently, come back to the screen, is there's a question. Applications for pupillage with Chambers are by way of CV and cover letter as opposed to the gateway scheme, and is there a reason for that? There is, for the person who asked. We find that we feel that we get a better understanding of who the candidates are if we do CV and cover letter, and that's why we don't use the gateway. We have used it in the past, we may use it again in the future. It's something that we keep under sort of fairly constant review. But for the moment, Mathias and I are both on the committee. Yeah. We feel that we get a decent view of who the candidates are through the current process. So that is why we do it. Before I switch back to the screen, does anyone want to ask anything in the room? The lady with the beige.
You mentioned various forms of adjudication, dispute resolution, so litigation, TCC, arbitration, adjudication. Could you give us an idea of the split? I don't know if you have statistics that are easy to give.
Let me just repeat. I don't know how good the speaker is. In case anyone didn't hear, it's a question for an indication about the split between different types of dispute resolution fora that we have in Chambers. Who would like to take that?
Sorry, David.
The most junior.
Go for it. Do it with confidence.
It's a very it's a very legitimate question. Because obviously you want to know what you'll be doing. The answer is it massively varies, and it'll vary year by year over the course of your practice. It does just vary. But you can probably guarantee that you'll do a mix of all of them at some point.
Yeah. It's quite cyclical, I think. I mean, it depends on what comes through the door, and also depends on what's happening in the industry. So there may be times where, for example, a particular sort of new issue came out, like for example, when the Grenfell Tower incident occurred, and then that led to the Building Safety Act from 2022, the new legislation which amended the Defective Premises Act. That created all of a sudden quite a huge amount of new sort of litigation. Not all of them would go to court, but at least it's sort of litigation work arising out of those particular types of defects. So you might suddenly see a sort of rise in those sort of work, and then whereas previously, on a junior end, you might be doing a little bit more of a mix of quite a bit of adjudications, also enforcements of adjudications in court. So it's interesting how sometimes adjudication might start as a private sort of forum, and then when you go to enforce the adjudication decision, you end up in a high court trying to enforce it. So it could sort of, one can link into the other, but then it really varies depending on the time and depending on your level of seniority. Like when I was more junior, I did a lot more adjudications and then a mix of litigation, arbitration, possibly sort of half-half, but leaning more towards arbitrations. And then over time, I've switched a little bit more towards just, more, maybe a little bit more domestic work than arbitration at the moment. But then it just varies from year to year and depends on what is interesting. And so you can also plan a little bit because you can decide what sort of work you want to do.
Yeah, thank you.
Great, thank you. And gentleman in the front row.
Yeah, you mentioned in the early years of tenancy, you get a lot of practice in the county court, and that's really good for cutting the teeth and gaining advocacy experience. I'm wondering to what extent that continues into the more senior junior years. Say, for example, when you're on bigger cases led by Silk, to what extent do the juniors get involved in the advocacy?
I think I would say that depends quite a lot on the individual. Yeah. So some members of Chambers end up, by design or by chance, normally a combination of the two, doing a massive amount of lead work. If they do that, they will do less advocacy for themselves because you have to share. Some members of Chambers, who I am one, were very rarely led. So, I was led before I took Silk. not very often. Often enough to find the necessary referee, and that was about it. And so I always did more for myself. Yeah. But it varies a lot. And one of the things that you need to think about when you're talking to your practice manager is what it is that you really want to do. Because everyone says at the start, I want to do my own trials. Of course they do. And some people do want to do their own trials. Some people, as they develop in their practice, actually find they are more interested in the bigger projects where they work as part of a team. They may be more interested in, they may for example, prefer arbitration, which is often, the projects are often bigger and therefore more likely to be a team job than court, where it's often a bit smaller, at least when you're a junior. And so it varies massively. However, I'm sure you all know it, we do pretty well for advocacy at the construction bar compared to the commercial bar as a whole. Compare the commercial bar to areas of the law like crime or immigration or something, and we're not in court very often. I'm sure you all know that.
There's a real spectrum.
Yeah.
No, but that's certainly true. I think the reason for that is because, as I was saying just a moment ago, with some of the adjudication work, for example, that we do, that leads on to high court litigation. So I mean, personally, over the past 10 years, even from a junior, very, very junior stage, but up till now, I do quite a bit of sort of adjudication enforcement and sort of, Part 8 hearings, which are sort of short hearings, one day normally, on a self-contained point of interpretation. And you could be in front of a High Court judge at a very early stage because of that, whereas compared to other areas you might not necessarily. But equally, I might still do one or two county court hearings here or there where the, a particularly interesting or important point arises or the value justifies it. I mean, I was in Central London County Court just a couple of weeks ago doing a preliminary issues hearing on a very interesting limitation point. So that advocacy sort of carries through. But then ultimately, as Jennifer said, if you want to do more legwork, you can. And then you're basically at the mercy of your leader as to how they want to divvy up the work and how much they want to share the advocacy.
You look as though you're about to say something.
Oh.
No, sorry. Yeah.
So really helpful, thank you.
Just a question in terms of the expert work. So I understand construction is obviously quite heavy in expert work. During pupillage and after pupillage, do you sort of undertake training for the cross-examination of experts because it is quite technical, and do you sort of have ongoing training within chambers on that?
Just in case the speaker didn't pick that up, the question was about whether we have any specialist training for dealing with experts because they are so technical.
Well, actually, so I haven't in chambers, although recently there's something called the SCL, the Society of Construction Lawyers, and we're all members in chambers, and recently they ran an enormously helpful cross-examination workshop for a day, which I attended, and as part of that, because it's not just lawyers who are members of SCL, there are also architect members, engineer members, quantum members. They all came as well, and the advocates practiced cross-examining them in front of silks from relevant construction chambers, and I received a day's worth of feedback from 2 silks. And so, yes, there is training available. I haven't had it in chambers, but I have had it elsewhere. And if I have questions about anything, there are people I can ask in chambers.
Yeah. And I think a lot of it, quite often, as with almost any area of the bar, I suppose, you might not get specific training. Yes, the SCL would perhaps do something like that every now and then. But then on a more long-term basis, you would probably learn by observing. And also, it's also trial and error, so you do need to do it anyway. So, you're not expected to be perfect the first time. So it's a combination of, being in a led case as part of a bigger team where you observe your leaders doing that sort of work and seeing how they put together that cross-examination. You would help them in that process as well. And then once you get to a certain stage, maybe 2 or 3 years more down the line, then you might get dished out, so you might get some advocacy dished out to you, and then you get to sort of test that out as well yourself, and you figure out what works and what doesn't. But it's a sort of a sort of less steep but sort of slower burn sort of learning curve once you get into tenancy, and that's a sort of almost like a long-term learning process.
Before I switch to the last couple of questions on the screen, is there anything else in the room? Okay. We have a question. How would we say that the Building Safety Act has changed the work done in chambers? Who wants to go first?
We kind of have addressed that already a little bit.
I think we probably have. Actually, I'm controversially going to say not a great deal. There's a massive amount of cladding work and firework, but there was always going to be the moment Grenfell happened, and there was firework before Grenfell anyway. It just wasn't in the press. The way you run, prepare, test, analyse evidence cases is all the same. What the Building Safety Act has done is given us a new piece of statute law. So there's some new law, and it's giving rise to, I assume everyone on this panel has got quite a lot of Building Safety Act cases going on. It's new in the sense that there's a new Act of Parliament, and whenever there's new law, you have to learn what the law is and apply it. It's a big Act of Parliament, so there's lots of things that aren't known about. But substantively, I don't know that it's changed what we do, it's just changed some points of detail.
Yeah, and maybe the volume in terms of, or maybe not, less so for us. Maybe I certainly know solicitors who had to deal with a lot more cases because of the extended limitation period, rather than just the usual 60 years. You now have 30 years worth of potential cases just coming through. So some of them would deal with that in the first instance, and then when it sort of trickles down to us, then we would also deal with that. So the volume might change a little bit depending on which member of chambers you're talking about. The only other limited area I think it might change it is where because the Building Safety Act has also introduced elements where you make applications for orders which can only be granted by the first tier tribunal, for example. So every now and then you get members of chambers, both in this set and others, who might get get a trip down to the first tier tribunal in the property chambers, where normally landlord and tenant work is being done and not our work. But because of the Building Safety Act, we need to do those works in those tribunals in a different forum. It's a very different environment, but that probably is the only other change I can think of.
Yeah, that makes sense. I think the next one is probably for one of you two. Maybe not. What makes being a barrister at Atkin Chambers unique?
Oh, wow, unique. Well, I think I would always advise that the most important thing when you're applying for pupillage is to figure out what each set actually does, which is often easier said than done. And it feeds into the pupillage application process, because the worst thing you can do in a pupillage application is to get that wrong and to say, I want to come to your set to do X work when they actually do Y work. And also, chambers' websites are not always that clear about what they do, because they have, for commercial reasons, there are reasons why they might market themselves as doing a lot of a type of work when actually they do relatively little. So anyway, with that being said, what makes us unique is that we do a very specialist set of work, and we do it to the highest level and all over the world. So that would be probably the most important thing. In addition to that, something which I felt in applying for pupillage here and felt during the pupillage process and even into tenancy is that these chambers are very supportive, and people from the most junior people all the way up to the most senior people really are pleased to see you succeed and really want you to succeed. And so you feel all the way through that people are interested in what you have to say, and they want to help you along the way. And so that applies all the way through. As a very junior tenant, you often go around, well, I mean, it happens all through your career, I understand. You will go around chambers and ask people questions, or go to tea in the afternoon and ask people questions, and people are always happy to help. Yeah, those two things, I would say.
Absolutely, I agree with that, thank you. Well, we're probably out of time. I would wrap it up, but there is one final question on here, which I think is a question that worries a lot of people, so we better just touch on it before we finish. In terms of mini pupillages, how many are expected? Should they be particularly in construction law? And if you don't have mini pupillages, is there any other way that you can compensate for the lack of mini pupillages? Most people have done a few, one or two, sometimes more. Some of the people have done them in construction law, not everyone. But I think this question is really targeted at not the fact that not everybody is able to do a mini pupillage for a wide and varied range of reasons. I can't speak for other sets of chambers and other pupillage committees, but on our pupillage committee, we recognise and allow for the fact that not everybody can do mini pupillages. If people have done mini pupillages, they're useful evidence because they go to explain why you might be interested in a given field of work. If people haven't done mini pupillages, then we just look for that evidence by some other mechanism, which can be a wide range of things. Sometimes it's personal experiences, sometimes it's case law they particularly liked, sometimes it's something they've read, but we recognise that not everyone can do mini pupillages, and we allow for that. I can't speak for any other sets, but that's the answer to that question. Right, we best wind up. To those online, the webinar will shut down in a moment, so thank you very much for coming. We appreciate your time.